Is the video?
I just see the numbers.
Yeah.
Is it going to count down to 0?
Yes, it will. Hello, everyone. Welcome to another exciting live stream with immigrationquestion.com. Our topic was carefully selected to provide insights into transitioning from a work visa to a green card and what you need to know. My name, once again, is Kunal Bechu, and I will be your host for this session. Many people on temporary visas, like your H-1B and your L-1, are qualified to apply for a green card, but don't know where and how and when to start. In today's live stream, we will gain the important insights into moving from a temporary work visa to obtaining a green card and achieving a permanent residency. Please join me today to welcome a seasoned attorney in today's session, attorney Deirdre Nero. She has founded the Nero Immigration Law in 2009 and specializes in business immigration, including employment-based visa petitions. She is passionate advocate for immigration reforms, immigration rights, representing clients across all 50 states internationally. Welcome with me, Attorney Nero. We are pleased to have you once again to join our session today.
Thank you so much for having me. I'm really happy to be here.
It's definitely a pleasure. To our audience streaming on various online platforms, it's time to grab your notepads and pens, and we're about to have an exciting session. Uh, Thank you. So, for those joining us for the very first time, I have some great news to share towards the end of today's program. So, please ensure that you stay glued to the entire session. You don't want to miss this. Trust me. What we have at immigrationquestion.com and prepared for you is going to really be exciting. Just to go through a quick Q&A with you, Attorney Nero, is I would like to start off by talking about the available pathways, Attorney Nero. Could you run us through the primary options available from transitioning from a work visa to a green card?
Yes, absolutely. So this is a really meaty topic, so we're going to talk about as much of it as we can. But of course, if you guys have additional questions afterwards, you can always reach out and ask for more detailed answers, especially for your specific situation. But like you were mentioning, there are certain non-immigrant work visas like H-1B, L-1, O-1, TN. Those are just some
Yes.
examples. E2, where a lot of times those people that have those non-immigrant work visas are going to want at some point or need at some point to transition to a green card. So there are, a couple of pathways there. Just like how the different visa categories have letter and number designations, we look at the different types of green card categories in different classifications. So we have your EB and then a number, usually. EB means employment based. And then we have categories, EB1, EB2, EB3, EB4, EB5. So those are your primary kind of classifications that you can transition into off of your H, L, O, TN, etc.
Yes.
Depending on the person's actual qualifications and situations, you're going to decide which of those green card paths is going to work the best. So, for example, a typical H-1B worker who's a professional working at a U.S. company, they're, a W-2 employee at that company. They're not one of the owners of that company, or they're not self-employed. They're just kind of a traditional worker on an H-1B. Their usual pathway is going to be an EB2 or an EB3, which will then have a 3-step process where the company is sponsoring the residents, just like they sponsored the H-1B. And then you start with the labor certification with the Department of Labor.
Mm-hmm.
I know you want to get into that stuff in a little bit more depth, so I'll just touch it right now. But that is the first step. And then once the labor certification with the Department of Labor is approved, then you move on to the portion with immigration. The company files an I-140 petition for sponsorship, which is kind of like the permanent version of the I-129 petition for the H-1B visa. So the I-140 is like the permanent version of that for the green card. And then when the I-140 is approved, the person will either do consular processing at their home country U.S. embassy, or if they're living in valid non-immigrant status, which is mostly what we're talking about today in the U.S., they can do a adjustment of status, an I-45, to at the end of that process finally have the residence, the green card. So that's going to be typical for your workers, right? Your H-1B workers. Could also work for O-1 as well, right? Because the O-1s are sponsored by companies. But a lot of O-1 visa holders who are extraordinary ability might opt for an EB-1A, which is an extraordinary ability pathway to residence, and has similar, not exactly the same, but very similar qualifications, requirements as the O-1. So a lot of O-1 holders will opt for that. And one of them, even though they have a sponsor and could do an EB-2 or 3. And the reason is because when you do an EB-1A, you can, number one, self-sponsor. So maybe they want to drop the sponsor. You don't have to self-sponsor, but you can self-sponsor. So that's one good thing. If they want to maybe get away from the sponsor that they had on their O-1. The other reason is because you don't have to do a labor certification with the EB-1A. So you're kind of like taking out one of the 3 steps, and you only have 2 steps instead of 3, which tends to be faster than obviously having the 3 steps. Likewise for an L1, those are in multinational managers and executives that have companies abroad that they work for, and then a company in the U.S. that they were transferred to as a multinational manager. There is a green card category that closely mimics the requirements of the L1, which is called EB-1C for multinational managers and executives. So a lot of L1A temporary visa holders, even though they could do an EB-2 or 3, right, because they do have the U.S. company, assuming they're not one of the owners, they could do that. Because there's another category that is a better mirror of the visa that they're already on, the EB-1C, the majority of L1s will, transition through that pathway. That pathway, even though it's also an EB-1, does require a sponsor, because you're still talking about that multinational transfer where there's a company abroad and a company in the U.S. And so you have to have kind of that company structure behind it. And then lastly, TN visa holders, they typically will transition through EB-2 or 3 because they're working for a company, so similar to H-1B. And then lastly, the E-2, depending if they're E-2 employees or they're E-2 actual investors and own their own company, they might opt for different options. So an E-2 employee could very likely be similar to an H-1B and do, for example, an EB-2 or 3, labor certification, I-140, and then consular processing or adjustment. Whereas the E-2 investor that's an actual owner in their company might have to look for a different pathway, maybe perhaps an EB-1A for extraordinary ability, or a lot of times we'll see EB-2 national interest waiver, which is like a special subcategory of the EB-2 that allows the applicant to self-sponsor. So that's really good for E-2 investors or the owners of their companies. But it also is really good because the national interest waiver, the waiver is actually what the word waiver stands for in the national interest waiver is waiver of the labor certification. And so in that case, they can also skip the labor certification. So that's a really good incentive as well to try and do a national interest waiver EB2 or an EB1 in either category that we mentioned. The three of those don't require the labor certification. So a lot of times that's an attractive option if the person properly qualifies. Like, you always want to make sure that you're not
Mhm.
going for something that's not going to work, right? Because even though
Yes.
in theory it sounds better than maybe doing just your traditional EB2 or EB3 where you have to do the labor certification process,
Yeah.
at the end of the day, if it doesn't get approved, then why did you go through all of that paperwork and time and money and
Yeah. Yeah.
work? So, like, and that's why working with a good attorney that knows kind of how to evaluate the case and make sure that you're going into um, a correct transition that has a really good possibility of working and getting approved. Because at the end of the day, like, that's what counts, right? If the green card doesn't get approved, then what are we trying to do here? Like, that's the end goal, is to get the person the green card. And so I'd rather maybe put them into a category that might take a little bit longer and has an extra step if we know that that case has a much better chance of getting approved than a case that maybe they're not exactly properly suited for, just
Mhm.
because that one doesn't have the labor certification. So
All right, awesome. Thank you. I think you actually answered most
that was
of
a big
the
answer.
yeah.
Yeah,
So you did comprehensively answer it
I tried.
regarding. Yeah, no, definitely. So just to go into, and we're really off to an interesting start. So now we know that the immigration process can sometimes have your hurdles, right? Could you speak a bit about handling these hurdles, especially around common issues like delays and requests for evidence?
It's really important that you think about this stuff, and that's why I like you to work with an attorney that is going to be straightforward with you and kind of give
Yeah.
you proper expectations right at the outset. Because I think one of the most frustrating things for clients is when they think the process is going to look different than what it ends up looking like, right? And so they think
Mhm.
it's going to be this fast, easy thing, and then it ends up being something that stretches out over the course of years. And maybe you
Mhm.
have RFEs and other things that are extra work that comes along during the process. So it's really important to have proper expectations, I think, number one, because that will help the person um, deal with the obstacles as they come. But you're right. An RFE is very common on most immigration cases,
Mhm.
especially like the more complex work-based cases. And as you get into some of these green card transitions, like it can
Mhm.
become quite complex. And one of the things that immigration loves to do is send an RFE. When we have a case that doesn't get an RFE, we're like
Mhm.
celebrating in the office, because it's like becomes so common to get
Mhm.
an RFE on a lot of these cases that you kind of just have to be prepared for them. There are some attorneys that have a mindset that they're going to hold a little bit of evidence back from the original filing, so that
Mhm.
when they get that inevitable RFE, they have like extra stuff to give. That's one mindset. I don't subscribe to that mindset at my law firm. We like to put everything that we have in from the outset and hope that we
Yeah.
don't get an RFE, because you don't always get the RFE, right? It's common to get an RFE, but you don't always get them. And so, like, we're just always trying to do the most we can right from the beginning to hopefully avoid the RFE. I mean, even on cases though, when we feel like we've given everything we have to give and we've really done a great job and properly and really thoroughly documented all of the requirements, you can still get an RFE. So you do need to be prepared for that and have kind of some ideas about creative ways that you can kind of reinterpret the evidence and reimagine some of the evidence and maybe come up with some new things to submit at the RFE stage. And it's also really important to just be able to make very clear arguments towards each of the points in the RFE. So that's definitely one obstacle, but it's not impossible to overcome. I would say the majority of cases that I've answered an RFE on have ended up getting approved. So by no means does an RFE mean that your case is not going to get approved. So I don't want you guys to get discouraged when you get an RFE. It's becoming just commonplace for the officers at immigration to issue RFEs, a lot of times because they need more time. So as they instituted premium processing on a lot of these employment-based green card categories, which most of them now you're able to use premium processing, it became more and more common for the RFEs, because the RFE is a way for the processing clock to stop, right? And they don't want to have to refund your fees, right? So if they don't meet the deadline of the premium processing, they're supposed to return your premium processing fee, and they don't want to do that. USCIS runs on fees that they get from the applicants, and so that's a way for them to stop the clock, right? Is to send an RFE and not have to refund your RFE file, your premium processing filing fee. So you know, they're not going to say that officially, right? That's just the lawyers guessing that that's what's happening. I mean, we're all, if you ask pretty much any immigration lawyer that works on this type of stuff, they will agree that that's likely what is happening in a lot of scenarios, especially if there's a premium processing. You know, not every case is it because you premium process that you got an RFE, and there's a lot of good reasons to premium process, even though it makes the chance of you getting an RFE to be more likely. But you know, it's definitely something to consider. The other thing that you mentioned is just like the delays, and that is something that you have to properly consider beforehand, because you want to understand, like, do you need to extend your non-immigrant visa status? Like, what does that look like? Especially if you're an H-1B that has an ultimate time limit of 6 years. You know, did you start the green card process early enough to be able to take advantage of post 6-year extensions under AC-21, which is something that you can perfectly do on an H-1B. You can have it for 7, 8, 9, 10, 12 years, but only if you start the green card early enough so that you can take advantage of those post 6-year extensions. So it takes a lot of pre-planning to really consider a lot of that. Another thing that a lot of people need to consider in terms of the delay is, like, are they going to have to renew their non-immigrant visa? Is that going to be a problem with the immigrant intent? Potentially, maybe they want to opt for consular processing because of that reason, even if they're living in the U.S. in valid non-immigrant status. So when I have H's and L's, which are pure dual intent, if they're living on a valid H or L and we're doing their green card, like, you know, there's really not a lot of reason for them to opt for consular processing. You know, I think an adjustment of status is usually what they would opt for, properly so. But maybe when you're looking at things like O1s and E's and TNs, to some extent, it might be better for that person to consular process so they can keep using their non-immigrant visa up until the time that they get their green card. If they opt to adjust, they're not going to be able to keep working and traveling on their non-immigrant status like they will if they're an H or an L. So those are important things, and like little nuances that if you work with a good immigration attorney that understands all of that, you know, and you can do the proper planning ahead of time, so you're not caught in a situation then where you're unable to travel, you don't have proper authorization to work at a given time. The traveling restriction can be really burdensome for a lot of people, depending on what type of job they have and what their circumstances are. So that's definitely something to consider. And then also, like, giving up your underlying status can be scary, because what if your green card case doesn't end up getting approved, and then you have no underlying status if you're just relying on like the adjustment of status to keep you legally in the US and working and with a travel permit. So that can be really risky. And so that's something else that you need to consider. So like at my firm, we really do like thorough evaluations of the person's situation to try and properly strategize for that person, because this is by no means a one size fits all solution, right? Like you have to tailor it exactly to that person's situation, what non-immigrant visa they have, the timing, how much time they have left on it, if they're able to renew it or not, when are they going to renew it, you know, how are they going to just do an extension of status, or are they going to travel out to get a new visa, how is that going to interact with the green card case, and what stage of the green card case they're at, because that will also make a difference, right? So this is all a bit complex, and it really needs to be tailored to the actual person's circumstance.
Certainly. Thank you again for that wonderful insight. So it actually leads me into my next question. Employees are a significant part that they play, especially in this process. So could you tell us what responsibility that employees have during this transition, and what is the legal obligation that they might look like?
So for the employee versus the employer, there's going
Hmm.
to be different obligations, but I think for both, it's very important to be honest with your attorney. Make sure that the attorney understands exactly what's happening with your status and with your case, especially if the attorney's coming in maybe just for the green card portion and they didn't work on your non-immigrant visa um, first, right? Because
Yeah.
then that attorney needs to understand exactly what your circumstances. So I think for the employees, just making sure that they're being honest. I also think like having an open line of communication with the employer and the employee to make sure that everyone kind of understands what's going on there, because and that the attorney, if the attorney is representing both, that the client, employee, and employer understand that if it's a dual representation situation, there's not a lot, there might be circumstances where
Yeah.
things are getting disclosed that maybe one party or the other doesn't want to get disclosed. So that all needs to be kind of put out ahead of time, and that situation needs to be kind of signed off on, right? Because otherwise, if the employer comes to the lawyer and says, "Well, I'm planning to fire them," like, what is the lawyer supposed to do if they're representing both and have
Hmm.
obligations to both? And so all of that needs to be made like really clear ahead of time. And I think that for the employer and the employee to understand, that they're both working with the attorney has the obligation to both parties, and for everyone to just try to stay as transparent and honest with each other during this process. Because sometimes these processes take several years. And so something might change in that employment relationship where, um, maybe the employee is going to be terminated or wants to leave that job. And then, they have to figure out how that's going to affect their process, and the attorney is going to need to step in and try to manage that without any conflict between the interests of the employer and the employee, which can get a bit complicated at times. So that's definitely something to keep in mind. But I think like the main obligation beyond what I just said is just for the employer and the employee to really provide the attorney with all of the information that the attorney needs and be honest about it, right? And not try to give any false information or any documents that aren't truthful, and just be really upfront with the lawyer and with their employer about all of the information that needs to be disclosed, because
Yeah.
honestly they dig pretty deep on your background on these cases, right? Not only your educational and your experiential background in terms of your work and your credentials, but also on just your past life, criminal history, the places you've lived, all the jobs you've had in the past, your family members,
Yeah.
the so all of that is going to have to get disclosed. Medical issues, you have to do medical exam, like, so there's a lot of kind of personal details that are going to be coming up as you work on one of these cases, and so you need to just understand that it's important to full
Yeah.
disclosure is important. You don't want a case to get denied because maybe you didn't disclose information that should have been disclosed, and then therefore it wasn't disclosed on your case, right? Um, a lot of times people think that they can hide information, but they would have been better off telling the truth. And then, because a lot of times the attorneys know ways to, make that situation better, or maybe
Yeah.
there's a way that we can, do some kind of um, minimization
Mhm.
of the impact of whatever thing that the employee thought was going to be a detriment to their case. It really depends on, again, the situation. I hate to keep saying that, but every situation is very specific. But in general, I think just full communication between employer, employee, and attorney is what's going to be the most important.
Really awesome, and again, thank you for your feedback and I'll say, the knowledge that you have actually partake into the rest of the audience. Deirdre Nero, for a platform that seeks to aid the immigration journey and of immigrants that provide them easy access to verified attorneys like yourself, could you tell me your thoughts about immigrationquestion.com, how helpful a platform like this could be to the immigrant community?
Very helpful. I mean, any way that people can get information, especially free information from reputable sources and not, going on TikTok and watching videos made by God knows who, and you don't
Yeah.
really know what the person. And it's so funny because a lot of times the short little videos and things,
Mhm.
it's not that the information is false. It's just that like they're showing you on like the Titanic, right? The tip of the tiny iceberg, but underneath the surface, there's the
Agreed.
giant,
Yeah.
enormous
Definitely.
thing and so it's important like to just not put too much stock into little things that you hear, but you go to a reputable source, we can get more detailed information from people who actually, work in this line of work and understand the nuances of all of this and not just rely on like what your friend or neighbor told you or what you found on a Google search if it wasn't from a reputable source. So I think this type of platform is really valuable, um, especially that it's
Hmm.
free and easily accessible is always
True.
nice.
Very
Um,
true. So again, thank you, and let's jump into our Q and A.
sure.
I'm mindful of the time as well. So to our audience, please can you post any questions that you have in our chat? We are going to open the live Q and A session soon, and we will answer as many questions as possible. While we're waiting for that, I see there's one question that actually is up in live. So I'm currently on a H-1B visa, been working in the US for 5 years. My employer filled the green card, but the process is slow. Can I change jobs during this time, and will it affect my green card application?
So there are ways that you can change jobs, but you have to be very careful that you're doing it at the right point in your process.
Hmm.
There's something called portability, which basically is when someone can change their green card case to a different employer, but it has
Hmm.
to have been pending for a certain amount of time, and it has to be at a certain stage of the case. And so we don't know those details for Javier, but but yes, it could be possible, but not at every stage of the case. So you have to just be mindful of that. Also, if you're still living and working under your H-1B, which it sounds like you are, and which you should be if you're on an H-1B, um, you you could also change your H-1B employer, but then you have to make sure that the employer that is your prior employer that's sponsoring your green card is not going to terminate the case. And if they do, if you quit, want to withdraw, you need to make sure that you're able to take advantage of the portability provision I mentioned to move your green card case to a new employer. And so it's doable, but you have to just make sure that you're at the right stage of the process. The good news is if you filed your green card already and you're at year 5, you're likely going to have time to have more than 6 years on H-1B. So that's good. You can take advantage of those provisions of post 6 year extensions as well as the portability provisions. So it is possible, but you need to check at what stage your green card case is at to know if it's going to work or not for you, Javier.
Certainly, and thank you for that question. Let's just see this. There's another one popped in. So, green card application in process, but my employer wants me to relocate outside the US temporarily. Will this affect my application? Should I tell the US CIS about this?
Okay, so they could affect your application if you are doing an adjustment, right? It depends on what stage of the case you're at. If you are, for example, already have an approved I-140 and you filed an I-485, you could try to change that to consular processing. If you filed a consular processing and not a 485, you should be able to relocate temporarily outside of the US and still maintain that green card case. So there are ways to do it. You definitely want to disclose to USCIS. There's never a good reason to try and hide that stuff because they're going to know, like when you leave the US, that's going to be record, right? So that's not really something you can hide. So disclosure is always a good idea. You don't want to seem like you're hiding information. But you do want to see kind of at what stage that case is at, and if you had either consular processing or an I-485, if you can turn that into a consular processing, if it was a 485, that's probably going to be your best bet for maintaining the green card case, even though you have to temporarily live abroad.
Certainly, and thank you for answering that. So I'm on a L1 visa, married a US citizen. Can I apply for a green card through marriage, or do I need to go through employee sponsorship? What's faster?
Oh my gosh, lucky you! That you're in the best situation, Amara. Like, you definitely, if you're married to a U.S. citizen already, I would opt for a marriage-based green card. It's going to be faster. It's going to be much less expensive. It's going to require much less onerous documentation. So I would definitely recommend that you get your green card through your marriage. You can keep working on your L1 until that's approved. And honestly, like, your employer doesn't need to be involved, which is great, because it's not going to be more things for your employer to do. But at the same time, it's not a reason for them to get upset with you. You're still going to work on your L1 until you get the green card. And if you have no intention of leaving that employment, you can just stay on once you get your green card. It shouldn't affect your employment at all, even though you're not working under an L1 anymore. You would just have to present your green card to them so that they can update your records and your I-9. But I mean, you should be golden there. So I think that's a really good opportunity for you to do your green card through your marriage, and get it probably much faster and with a lot less headaches than you would if you did it through your employer sponsorship. And honestly, your employer might actually be happy, because it's less work for them, it's less expense for them. It would be something that you would be kind of handling on your own without them having to get involved. So not many employers I know would be upset about that. They would probably be quite pleased, actually. And it's going to be much faster, I think.
Awesome, thank you, and thank you, Amara, for the question. I think we got an incoming caller. Let's see if we can take this call.
Oh, this
Hi
is
there,
live.
welcome to immigrationquestion.com. You are live.
Hello, good evening. I'm calling from Nigeria.
Yes, go ahead with your
Okay, so I
question.
have a question. My friend is on an L1 visa, but her employer is not willing to help her through the transition process. She's a bit confused on what she should do, and that's why we're calling. Thank you.
Okay. Wow, that's a hard question to answer in a small amount of time, because there might be many options for her, but it really depends on what type of expertise and work she has. She might want to look at green card options for self-sponsorship, such as a EB-1A or an EB-2 national interest waiver. Again, those are two that she can sponsor without her employer being involved, but she has to make sure that she would qualify for either one of those. I mean, I'd be happy to talk to your friend individually at another time to help her figure out if she qualifies for one of those self-sponsorship green cards. But unfortunately, if the company's not willing, then the typical green card pathway for an L1, the EB-1C, which is a multinational manager green card, they're just not going to be able to do that without the company's support. So she's going to have to look at one of the other self-sponsorship possibilities.
Certainly,
Or
and thank
a
you.
family base, if she has a U.S. citizen relative that she could qualify for a family-based green card, kind of like the last question that we answered, where she was married to a U.S. citizen. That could also be an option for her if she has a qualifying U.S. citizen or permanent resident relative.
All right, I think we can squeeze Sophia's question in. So I'm currently on a H-1B visa, but my employer hasn't started the green card process yet. How long can I wait? Should I push them to start it fast?
So what I was mentioning earlier in the live stream is that there is this law called AC-21 that allows you to get post 6-year H-1B extensions if you start your green card early enough. So what I would say is that by year, 4.5 of your H-1B, you need to be pushing your employer to start your green card process. Because if you want to be able to take advantage of the post 6 year extensions that will allow you to maintain your H-1B for longer than 6 years, you have to have had your green card pending for at least 365 days by the time you reach that 6 year mark. And so that's why I'm saying by like year 4.5, you really need to have that organized and ready, because if you're going to have 365 days of it pending already, it has to be filed by, basically the 5 year mark. So 4.5 might even be a little late. Maybe like at the beginning of year 4, you need to really start pushing the employer to see if they're going to be willing to sponsor your green card or not. And, if they know that means that you can stay in H-1B time longer, that might be great incentive for them. If you're a good employee and they want to keep you, that's probably going to be some incentive. Otherwise, you might want to start looking for a different employer that you can transfer your H-1B to. You can do an H-1B change of employer if that other employer is going to be more willing to sponsor a green card for you. So that's something that you want to consider. And you want to have all of that kind of known and ready to go by I would say the start of year 4 of your H-1B, so that you have enough time.
All right. And again, thank you very much for answering that so comprehensively. I think judging by the time, I'll say, you know what, it's a wrap to everyone that's actually attended and joined. Keep the questions flowing, and we'll definitely have that passed over to Deirdre itself. So thank you for everyone for joining us on, and a special thank you to our guest speaker for sharing your time and expertise. We cannot wait to have you back in our show.
I'd love to come back. This was fun.
Definitely, yeah. And you know what? With your knowledge and insight, we'll definitely love hosting you once again.
Great.
We hope this webinar has answered some of the most pressing questions to everyone that has actually has joined us and actually put through the questions. Very, very importantly, for those who actually stayed tuned for the entire event, and if anyone who have missed this or missed any part of the session, we'd love you to listen again. Catch up with us on Spotify. This live stream is being recorded. We'll be live on our listening device on any Spotify applications. Very importantly, search Borderless Talk by immigrationquestion.com and listen to today's session and any previous one on the go. To those who have stayed tuned right up until now, the good news is that we are thrilled to announce that we are taking your immigration question, which has got a little, and I'll say greatly easier today. So what I mean by that is that we have actually increased the need of, especially with everyone having mobile devices, immigrationquestion.com has dedicated an app to bring all the website features in the hands of users today. So attorneys alike and our wonderful audience, it makes communication much more easier and smarter. You'll be able to communicate, claim leads on the go, maintain engagement on the community forum, and that's really amazing. What do you say about that, Deirdre?
I think that's awesome. Good for you.
Yes. So definitely download it now on any Google Play Store and on Apple Store itself. Get the app onto your phone. You can get communicating directly with a qualified attorney on the go itself. So see you on our next session at the same time, same platform. We'll all be joined with another attorney the following week, which is Attorney Jacob. And before we leave today, once again, I'll stress the fact is that let's get this app downloaded by any Google Play Store and Apple Play Store. And we will be live once again to talk about the topic, which is going to be very interesting. It's fiancé visa explained in detail, especially for those who are willing to get married in the next coming months and years. This is a topic that will be really interesting. So bring in, your pens and get your notes jotted down for that session. Get the steps to bring your partner into the US, and you don't want to miss the session. So once again, thank you for joining us at the session. From my side, have yourself an awesome day and a blessed weekend. Thank you. Goodbye.